Hey guys, the buzz Manson felt from his recent birthday celebration and accompanying news that his litigation team had whittled the suits against him down from 4 to 1 has been, I regret to report to you if you support him, harshed. If you're keeping score at home, the suit count went from 4 to 1, but it's now back to 3. On top of that, his case against Wood and Gore has been delayed again. So he had a great week before and not such a good last week. Let's start with the Wood case. The AntiSlap motions were finally to be decided this week, and depending on the ruling, the case might finally move forward or just languish on appeal, but at least something would have happened. There'd be some clarity as to whether the court thought Manson could proceed with the full scope of his claims or whether they would be substantially narrowed. However, now that's off. The court has moved the motions hearing to April 11th. Now remember, these motions were originally filed April 28th of last year, so almost a year before this motion gets decided. Now, the AntiSlap is not some ultra defense in itself. It's designed to say, hey, if you're subject to a lawsuit that has a speech-related claim in it, we'll pause the case temporarily and fast track it to a hearing to see, hey, does that claim, the actual claim itself, at least have some merit enough to proceed? And in theory, that should be easy to do. You're generally not going to do discovery. The plaintiff is supposed to at least come up with a little bit of evidence for the elements of the claim and show there's a legal theory to support them or not. And then the judge decides, yes, this can go forward, or no, it cannot. But taking a year to decide that, it's obviously unfair to the plaintiff, say Manson here, if he has a claim with merit. He can't even do discovery or evidence collection for an entire year. I mean, some of that discovery could be disappearing, right? So it's not good. But it's also unfair to the defendants generally, and here Wood and Gore, because they're supposed to be able to have a case tested quickly and not set in litigation purgatory for an entire year. But it is what it is, and what it is another delay in Manson's case. Now let's move it to the New York Jane Doe. Little has happened since we saw the case removed to federal court by Manson. It's definitely a bummer for him to be sued all the way across the continent. Out of court, the plaintiff's attorney has been working social media with a press conference and a meme generator. In court, the plaintiff's attorney has been notified that, hey, look, you need to be admitted in this federal court either directly or pro hac vice if you want to keep representing Jane Doe. So somebody on her side needs to be admitted to practice in front of that federal court. And Anderson, well, he's licensed to practice in New York, so he can quickly apply for admission, or he can associate local counsel and then come in pro hac vice. Pro hac vice means that you're allowed to appear and participate in a case without being admitted to practice in that federal court. So you would have a local attorney who is admitted, and you would come in and probably do all the work. So on Manson's side, he has admitted counsel representing him already, and King's team have declared their pro hac vice motions are coming soon, so they'll appear in this case as well. Responding to some comments on the removal to federal court, I don't immediately see an advantage on the statute of limitations for Manson by removal. Generally, federal courts for state claims use the state substantive law to decide those claims. They don't use separate federal substantive law. They use the state claims. They're just doing it as a federal adjudicator of the situation rather than a local, but they don't change the law. So that shouldn't change. But in fact, there's a potential disadvantage for Manson because the Second Circuit Court of Appeals, which covers New York and some other states in terms of federal law, has said that California's anti-SLAPP statute is considered procedural. So remember, generally, the federal courts will apply the state substantive law for state claims, but their own procedure. State courts don't tell federal courts how to operate. So when the court decides that the anti-SLAPP is procedural and then it conflicts with federal procedure, then they're going to say you can't use it. Now, the Ninth Circuit, which covers California, said, no, we don't see that conflict. We'll allow the California anti-SLAPP. So there is a split across the country, and eventually the Supreme Court could remedy that by saying what the rule should be. It's procedural, substantive, whatever, and also just better drafting of legislation could also cure it. But for now, it's a split. So the new powerful New York anti-SLAPP statute, which seems to me very similar to the California one, probably is going to be considered procedural and not available in the Second Circuit federal court. So why would Manson go to a federal court if he's going to potentially lose this defense? Well, I gave some reasons last time. And remember, anti-SLAPP it's not a defense in itself. What it is the ability to get your case tested early. And then if the plaintiff has some merit to those claims, then the case is going to proceed anyway. But still, it would be giving up something. So I gave out some general reasons last time to go to federal court, but I think one of the best reasons that was mentioned to me that I didn't mention, and probably maybe the right reason, is a potential change of venue. So we had discussed before on the Manson Cases YouTube channel and podcast the connection to New York. And Andrea Burkhart rightly pointed out that, look, New York is not really a center of gravity of this case. And the connection's fairly tenuous. And she's talking about all these acts that occurred in all these other states and asking New York to adjudicate it. Like, what witnesses are in New York that have to do with any of this stuff at this point? Maybe even the things that happen in New York. I don't think those people are necessarily there. The parties aren't there. Well, that gets into potentially into this change of venue situation, because a federal court is, well, federal. It's part of a nationwide system. One thing a federal court can do is change venue to any other district where the suit could have been brought. And it's kind of based on convenience and justice and where the witnesses are, etc. Now, the Supreme Court has said if it does get moved from one district to another, that doesn't change the law that's applied. That's to keep people from trying to shop venues and making these change of venue motions just to get a more favorable outcome of their case. So it's not really an advantage from the law, say, if Manson were to move the case out from New York to, say, Texas or to California or something like that, if he could, not necessarily on the substantive law. So still, it would be an advantage to get it out of the court where the plaintiff wanted it, which first she wanted it in state court, now it's in federal. And if he could move the state, that would make litigating it for her probably more difficult. So that may be worthwhile in itself. And he'll have to justify it to federal court for the witnesses and things like that. There could be an interesting question in this situation that even though the Supreme Court says that you need to use the law of the state where you came from, how the circuits interpret whether anti-SLAPP law is procedural or substantive, I don't know that the case covers that. So if you went to a circuit that says, hey, look, we don't see a conflict between federal procedure and an anti-SLAPP law, maybe you actually could use that in that circuit because they're using their procedure. They're not changing the substantive law. I'm not going to run that down right now. You got to leave something to wonder about. I'm sure the attorneys will look at that if it becomes an issue. So maybe if he changes venue, he could get this anti-SLAPP back later. I just haven't run it down yet. But if he loses it, I'm sure they'd want it back if they could get it. And maybe changing venues, if it's procedural versus substantive, could be an angle for him. I just haven't looked it up. It's something to think about. I'm certainly being kept on my toes by the comments that are asking some pretty deep legal questions on this issue. So finally, the Ashley Walters case. It appeared from the docket earlier that she'd passed her deadline, and the docket even indicated the appeal was dismissed for failure to prosecute, but it also had that as an action item for February 8th. Well, like one of those scenes where they defused the bomb at the very last second, she has filed a brief before February 8th, and the docket is now showing her appeal is on. So although they had said it was dismissed, I guess out there they don't really mean that until the February 8th comes up, even though she had blown the deadline for the briefs. I don't understand all that. One thing you don't want to do is miss deadlines, but I guess they didn't miss it because they had until February 8th, it appears, and they diffused this bomb at the last second. So she has filed her opening brief, the court says, and we haven't seen it. They don't post it on the Court of Appeals website, but it is accompanied by a request to take judicial notice of certain statutes. So I think there's going to be two arguments in it. The first is obvious. Hey, the judge shouldn't have thrown my case out. The judge erred when he said I did not plead adequate facts that could have told the statute of limitations, reverse him on that, let my case go back. But the second, and I think very powerful argument is, the statute of limitations has been changed, and that's this judicial notice thing, I think, to encompass, I think, the timeline of her allegations. And it's retroactive for cases, at least in some of them, that haven't been fully adjudicated. And if your case is on appeal, it's not considered fully adjudicated, it's still considered pending. I think that's a winner. I think she's going to have her case reinstated. So that puts the case count against Manson as 2 in California and 1 in New York, and his case in California against Gore delayed. Whichever side you're on, don't get attached to any emotions from the roller coaster nature of these cases, as their status seems to change faster than the weather. And there will be more interim ups and downs before this thing is all over. That's all the updates I've seen in the last few days. Thanks, bye.